Hello, everybody. Welcome to the podcast. In this episode, I was fortunate enough to sit down with employment law mediator Steve Pearl to discuss what mediation is, what the process looks like, some best practices for parties attending mediation, and how COVID's changed the process. We also talk quite a bit about PAGA, the Private Attorneys General's Act, and it's a law here in California impacting a lot of California employers. Steve and two colleagues of his have recently done some research into what PAGA cases look like when they actually go all the way through trial and what those results look like. He recently published those findings in the California Labor and Employment Law Review. We discussed that a little bit as well. We've recorded this conversation in April of 2024, so let's jump into it.
Fantastic.
Okay. Well, welcome to the podcast, Steve. Thanks for coming in.
Yeah, it's awesome.
You're a mediator. Give us a little background about what you do as a mediator and your mediation practice.
Sure. So I've been mediating since 2010. I started working out of my office. I still had a practice back then as a lawyer. I almost said liar. and anyway, so I still had my practice and I was mediating. You know, I did that first year, maybe like 10 or 12 cases. I think I did one with you.
Yeah.
I think we did one together that first year in 2010.
I didn't, yeah.
And then in 2011, I went to one of the providers and I was there till 2020, right before the pandemic. I left in January and have been on my own since then, mostly mediating remotely, you know, from my home office. And
that's great. We'll get into that too.
Yeah.
That one of the dynamics, how mediation's changed.
Yeah, it has changed a lot. Yeah.
But so how well, a couple things.
Yeah.
Since it's top of my mind right now, I'll ask you about it. How has it been going out on your own?
It's been great. It's been great. It was really, the timing was so wild because I thought that I would do my mediations in my clients' offices, which is fine. And then and then COVID hit. And of course, we've all been working at home since then. I think I've done 8 or 9 in person in the 4 years now.
Wow.
Yeah, nobody ever asks.
Right.
Nobody wants to, at least in the cases that I do. I know other mediators have different experiences, but I had one last month or the month before, and that was probably the first one in a year that anybody asked me to do in person.
Okay.
So yeah, so mostly I'm just in my home office working with people over Zoom.
Okay.
And it's fine. It really works very well.
Great.
Yeah.
So for some of the listeners that might not have been through mediation yet, can you explain what mediation is and how it's different than litigation or arbitration?
Sure, absolutely. So mediation is a unique part of the litigation process. It's been adopted, at least in California, it's been adopted almost universally. Almost every single lawsuit, unless it gets resolved informally between the lawyers before mediation, it will go to mediation at some point. Almost everything does. And the reason why, I was thinking about this, like the reason why it's been so universally adopted is because it works. And the reason it works is because mediation is designed to give the power to the parties themselves to find a resolution that works for them. It may not be the resolution they want, either side, but it's a resolution that makes good business sense, that is going to save them the cost, both in terms of money and energy, mental attention, just work that you have to do to litigate a case. It saves the parties all of that and gives them some control over the outcome. You know, the alternative to resolving your case, whether it's mediation or informally or any other process, the alternative to that is go take your case to trial.
Right.
Go put it in front of a judge. Go put it in front of 12 jurors, and see what they think. Folks who they have other things going on in their lives, let's say, and do you really want to trust whatever the problem is to those folks? That's the issue. That's the problem.
Yeah.
So the way that mediation does that, you want me to keep
sure.
going?
No, and for a lot of people that haven't been through the process
Yeah.
or been involved in a lawsuit, they don't realize you're not a judge.
Right.
You're not appointed by the court.
Right.
Like the parties reach out to you,
Right.
and it's this private, semi-private. We used to meet in an office somewhere.
Yeah.
And they're just hiring a third party to help resolve your dispute. And a lot of clients are asking about, does it mean we have to settle in the day? They don't realize it's this
Right.
voluntary process. You're
Yeah.
not going to sit them down and not let them leave or get off Zoom until the thing's settled. It's
Right.
totally just, and I say free for all. It's not free for all. You
No,
bring
it's
the mediator
organized.
brings
Yeah.
the structure to the process.
Mhm.
But at any point, anybody can leave and say, I don't like where it's going, and can stop and walk out or
That's right.
turn off their Zoom. And I think that's surprising to a lot of people.
Mhm.
But how the process works and what's it take to be a mediator too? What kind of
Sure.
qualifications?
So as far as the process, again, the reason mediation works is because it empowers the parties to make their own decisions, including the decision to be there in the first place and to continue the mediation. So yes, if folks don't like how it's going, they have the ability to end the mediation, and folks sometimes do. They also retain the ability to make their business decisions for themselves, including what demands to make, what offers to make, how to respond to whatever the other side is doing, what information to provide to the mediator, what information to provide to the other side. Sometimes folks will tell me things that they don't authorize me to tell the other side. And of course, I honor those requests. Confidentiality and trust in the mediator are incredibly important. So yeah, the parties really are in control of the process. Of course, as a mediator, I have a structure that I think works and that I use, but there's a lot of flexibility in that. There's more flexibility now in mediation than there used to be. Parties don't always use the flexibility that there is, but when I started as a lawyer, so I've been a lawyer for 32 years, almost 32.
And what background on that too?
Yeah.
What type of cases did you litigate? Plaintiffs, defense side?
Yeah, I've been on both sides, plaintiff and defense. I've done employment law throughout my career.
Strictly employment law? Did you get into
No. I've
others?
done other things as well.
Okay.
But I started out at a big international law firm doing defense work, including employment defense. I defended individual harassment, discrimination, retaliation cases. I defended, in particular, one of the first cases I was assigned to was a large gender discrimination class action, kind of a precursor to Walmart versus Dukes, which went to the U.S. Supreme Court years later. Anyway, so I did that on the defense, and then I had my own firm where I did plaintiff's work. Worked in a lot of different areas of law, but employment law has been kind of the thread throughout, and has been employment law and class action work have been the mainstays of my mediation practice. And now that PAGA has assumed such an important role in wage and hour law and become such a larger part of all of our practices, it's a large part of my mediation practice as well. So that's kind of my history as a lawyer.
And when did you figure out you wanted to be a mediator? How did that?
So 2008, I was talking with a friend of mine, and he said, "Do you know this guy so-and-so?" I said, "Yeah, he's a friend of mine." And he said, "Well, he sent me a demand letter in a wage and hour case." And so I knew the lawyers on both sides of this case, both good friends. And I don't know if I volunteered to do it or they asked me to do it, but I ended up mediating the case. And we settled the case. It was a long day. We went to like 11 or 12 or whatever it was. But the case got resolved. Got home, had a migraine, couldn't sleep. But I really enjoyed it.
Cool.
And then a couple of years later, one of those lawyers was going to, I think it was 2010, one of those lawyers was going to take the course at Pepperdine. Pepperdine University has a really distinguished program on dispute resolution, and they offer a course for lawyers called Mediating the Litigated Case, 6-day class. And so I went and took that, and I was hooked. That was when I really decided that was what I wanted to do.
Cool.
Yeah.
And then you just started making the focus to become a mediator at that point. You still had your practice.
I still had my practice, but I started doing cases, and I started mediating small claims cases and limited jurisdiction cases, and the LA Superior Court had a program they called the Crash Program, where you would come in and do cases in a day. I did the Crash program. I did that back in the day too. Yeah, it was fun, right?
Yeah.
And so I did everything I could get my hands on, and then a year later I went to a provider.
Okay.
Yeah.
Great.
Yeah.
And then when you say a provider, what do you mean by that?
Oh, there are these firms that have, a ton of judges and lawyers who mediate and arbitrate cases. So I went to one of those firms.
Okay. And now you're on your own. So you've got your own mediation practice. And, for a background for a mediator, it doesn't take any special credentials. You don't have to go to this Pepperdine course.
No.
Parties can hire anybody off the street to mediate a case, right?
Absolutely. And there are some very well-known mediators. One of my instructors in the course at Pepperdine was a guy named Tim Pownall, who, if I'm not mistaken, was not a lawyer. He was wonderful. He passed several years ago. He was incredible. He would go to areas of high conflict and mediate conflicts using, really amazing. He would talk to people about their shared values, particularly in a religious context. He had an incredible knowledge of world religion, and he would use that knowledge to find areas of shared value, and he would negotiate these very high conflict situations where people were literally killing each other.
Wow.
And
wow.
Anyway, Tim was incredible, and he was one of my professors at Pepperdine. He was not an attorney, mediated thousands of cases, thousands of situations, and was incredibly skilled. So no, you don't need to be a lawyer to be a mediator. You don't need to be a judge to be a mediator. There's no certification process in California like there is to be a lawyer. Some lawyers prefer to work with judges. Some lawyers prefer to work with folks who have never been judges. And the parties, as we talked about earlier, the parties have full control over those kinds of decisions.
Yep. Now, it is useful, though, and as everything gets specialized, to have a mediator that understands the area of law that involves your dispute, right? And how important do you think that is? Especially in the employment context, I can tell. I've used some mediators that don't know employment law, and it's it can be tough getting them up to speed on certain areas of the law versus like you said, PAGA is becoming such a focused, specialized area of employment law and litigation. We'll talk about PAGA a lot here today, but it's nice when you're talking with a mediator that knows those cases. You don't have to bring them up to speed on the arguments, and kind of could see the arguments that are coming up around the corner and know how to head those off too.
Yeah. I think a lot of lawyers want to work with people who have subject matter experience in whatever the area is. There are a lot of people, particularly some of the retired judges, who will do a very broad range of cases, whether personal injury, real estate, employment, et cetera, et cetera. I think more among the non-judges, the lawyer mediators, I think tend to specialize in particular areas. So like for me, it's class action, consumer class, wage and hour class, PAGA, and employment. Those are really my areas of specialty. And I think there are areas where folks do want subject matter expertise.
Yeah, I agree. And it just speeds up the process, in my opinion.
Right. For you and for the mediator.
Yeah,
Yeah.
and saves the client money potentially too, and prepping for it. The briefs are easier. Like you don't have to set out all the case law. It's more of the facts, focused on the facts, not worried about the law as much.
Right. I tell folks I don't need briefing on the law. Like unless you've got some esoteric issue, that maybe I haven't seen in a while or at all, then yeah, go ahead and brief the law. But an ordinary kitchen sink kind of wage and hour case, PAGA case, or ordinary discrimination, retaliation case, you don't have to cite the basic,
and that's super helpful.
And it's not just me, obviously. It's any of the literally dozens of folks who work in this area. We all know what that law is.
Yeah. No, that's great. That's great. And it helps the attorneys a lot.
Yeah.
In getting it resolved.
Yeah.
So, let me see. So the mediation process, what's a typical session look like? And I guess we could start off with we kind of already hinted about it, the big change since COVID. I mean, prior to COVID, it had to be in person. You had to get your decision maker in the room. If I'm defending a client, I'd have to have the decision maker with me at the mediation. To the extent where we wouldn't even have the mediation if the client was out of town and missed their flight. Like it would be like, I don't think we can have it today, right?
Yeah.
And now that's totally flipped since COVID. Do you want to talk about that and kind of what the process is looking like?
Yeah, absolutely. So yeah, you're right. COVID has done a couple things, and Zoom mediations have done a couple things. One of which is that we don't sit down together anymore. And so we've lost that. It's so interesting coming into your office today. Like I so rarely sit down with people, and it's really nice to come in and sit here with you and be in person, like not be looking at a screen. So obviously we don't do that nearly as much anymore. As far as like people being present, one thing that's really nice about remote mediation is that I'll get the CEO. I might get the CEO and the CFO, in addition to the head of HR in the room. Whereas previously when people had to fly in from wherever they're based, I might only get the head of HR.
Right.
And then you and the head of HR are talking to the CEO mostly without me in the room, because that's how you want to do it. And so Zoom gives me more access to decision makers in these cases. So
the other aspect I don't know, it's just my sense. It seems like the client feels a little more in control over the day too, if they can log in over Zoom. Like you said, a CEO is more likely to pop in on Zoom, pop out, deal with issues, come back at the end of the day when it has to be inked or finalized.
Right.
So they get a little more control over their work and can be working while they're at their desk as well, while the Zoom's happening.
And you can as well, which is nice. It's nice for the lawyers not to be sitting in a conference room babysitting their client all day. It's got an interesting impact in the plaintiff's room. Plaintiffs most often, really one of two situations. They're either in their own homes, or they're in their lawyer's office with them, even though, and then they're in, in the conference room logged into Zoom. When they're at home, they're more comfortable. People who are more comfortable are more capable of making good business decisions, rational decisions. Rational decision-making, so there's been a lot of study about this. Daniel Kahneman, who passed recently, the Nobel Prize winner, he and Amos Tversky created the field of behavioral economics. And Tversky died before they gave Kahneman the Nobel Prize for it. Anyway, they did a lot of studying about how human beings actually make decisions. We're not rational actors like Adam Smith believed that we are. We actually do make a lot of irrational decisions, and we have a very hard time making rational decisions. And people have an easier time doing that when they're less stressed. You add stress and it makes it more difficult to make good decisions. So it's really interesting to see people more relaxed in mediation, because just coming into a conference room, if you're not used to that world, coming into a conference room and who's the mediator and what's he or she going to do
Right.
and say and think and et cetera, it's very stressful for
Right.
people on both sides.
Right.
The defendants, might have done it before, so they might be more used to it, but it's stressful for them too.
Yeah.
So
Especially
when
if you haven't
people,
been through it before.
absolutely.
Yeah.
So when people are in their own offices or in their own homes, they're more relaxed. They can tend to their own business. They can eat their own food. They can make better business
Okay.
decisions.
That's good.
Yeah.
Good point. So the economists you mentioned, any books you recommend?
Oh,
from
Daniel
them?
Kahneman wrote an incredible book. If you're interested in the way that human beings make decisions, he wrote a book called Thinking Fast and Slow
Okay.
about 10 years ago, and it's absolutely fascinating.
Great. I'm
Yeah.
going to keep picking your brain on books too.
Oh, sure.
As we go along, and the negotiation process and that
Yeah.
is fascinating, and it's something you could read and study. I've never been to the Pepperdine course about how to negotiate, but
You'd enjoy it.
Yeah.
Yeah.
Okay.
Yeah.
I think, I like the theory behind it.
Yeah.
But I think once you get in the room, you have to do it a lot to see how the process works. And every time, that's one cool thing I like about being a lawyer. It's not, the process is the same, but it's different. Every time I go into a mediation, it's different. Every time you've got a different mediator personality, client personality, facts different. It's always evolving, and that's what keeps it interesting.
Yeah, for sure.
But I like the theory behind it. The negotiation.
You should go take the course. It's I would encourage anybody really who does this for a living to go take the course. It's really, really interesting.
Okay.
I found that it put labels on a lot of things that I knew already experientially as a lawyer who had done a ton of mediations.
Yeah.
And I'm sure you would find the same thing.
Okay.
But it's very interesting to put those labels on things and then kind of gives you a new framework for thinking about them.
Yeah.
Yeah. It's a good course.
Cool. Yeah, I'll look into it. What is it? 6 days?
Mm-hmm.
Okay. Pretty intense. But
yeah. Two weekends. Friday, Saturday, Sunday, I think.
No, that's not too bad. Yeah.
Okay. Maybe Thursday, Friday, whatever.
Okay. So in person versus remote, any drawbacks on being remote though?
Yeah, you lose that connection. It's tougher to read a room. It's tougher to tell how. I mean, you still can tell people look away or they sigh or they tap their pen. If you're saying something they don't like. But it is tougher to read the room. It's tougher. People don't relate to each other the same way. They don't respond to body language the same way. Even between lawyer and client, the communication, you lose that nonverbal communication to a large extent. So yeah, it's different. Mediation still works. I think that mediation has continued to evolve through COVID. There are things that are different now in mediation than they were 5 years ago or 3 years ago. I'm not convinced that that all of that is because we're doing them remotely. I think some of it is just because mediation continues to evolve, and lawyers continue to adapt to what we are doing as mediators, and we as mediators adapt to what you all are doing as lawyers. And so there are things that are different. I'm not sure that they're caused by the fact that we're doing them remotely.
Okay.
And part of the reason I say that is because we had a meeting, there's an organization called the International Academy of Mediators, and they let me in, and we had a meeting, Southern California meeting a couple weeks ago. And some folks are doing much more in-person mediations than they are Zoom, but they're finding the same kinds of changes that I'm finding in my practice, where I'm almost entirely Zoom. So that leads me to believe that those changes are not so much about Zoom as they are about just a changing landscape.
Sure. Are you seeing more mediations coming back in person? And I'll qualify that too. I didn't think the mediation process was going to work over Zoom. During COVID, when we set up our first couple, I was like, we'll give this a shot. There's no way this is going to work. And then surprisingly, it was almost the same experience. We're getting cases resolved. And there are other benefits. I think there are some drawbacks, but do you see that trend staying to be remote on the mediation? Do you see more coming back in person?
For me, anyway, with my caseload, it's been 2 a year.
Okay.
I've had one so far this year. I'm guessing I'll have another.
Okay. Yeah. Okay.
And that'll be about it.
Yeah.
Yeah.
It's just so much more efficient for everybody.
Yeah.
Yeah. So huge efficiencies that
I
were
know
recognized.
other people, never really went remote. Folks in San Diego tend to do things in person,
Okay.
as opposed to LA or Orange County. But yeah, my caseload is staying almost entirely remote.
Okay. When they were in person, there's this whole, we talked about it briefly before the podcast, about whether the parties get together and do a joint session,
right,
or the attorneys get together. So any trends on that too? But I guess it's Zoom, or you could still have a joint Zoom room. I've done that with mediation before, with the mediator calls the attorneys in, and we're in a conference without the clients.
Right.
Do you see that happening in person? Any joint caucuses?
So my experience with joint sessions, joint caucus, is that when I started as a lawyer, early 90s, we'd go to mediation, we'd come into a conference room. Mediator was always a retired judge. He mostly was men. Be sitting at the top end of the table, and we would sit on opposite sides of the table, and you'd give an opening presentation, each side would, and then the judge might ask some questions, and nobody liked it, right? Nobody felt comfortable with it. Everybody felt like it just raised the temperature, and it took a couple hours to calm things back down before you could really start getting into things. And so people in Southern California in particularly moved away from that kind of joint session. In other places around the country and around the world, people routinely do joint sessions. It's really a California thing not to.
Really?
Yeah. And so, but that's the culture that we have, the mediation culture that we have here.
Yeah.
So
if we say the culture is a little more laid back and, or not laid back.
I don't think it's laid back.
That seems like pretty structured. Like, here's a judge, we're going to do this like a courtroom,
right?
Versus like we're going to start the mediation, and the mediator just starts talking to one side without the other side and starts going back and forth.
I think lawyers really asserted themselves. Sorry, go ahead.
No, go ahead.
I think lawyers in California in particular really asserted themselves in saying, we don't like this and we don't want to do it, and we're not going to do it.
Okay.
Yeah. I think that's what happened.
Okay.
So the lawyers weren't being real laid back about it. I think they really just asserted themselves. Okay. And but in other places it works. And in employment cases in particular, you never have a joint session. Nobody wants to sit down together. When I started as a mediator, so 2010, 2011, I would always ask people, do you want to do a joint session? Can we do a joint session? I would try to talk to people about the benefits of joint sessions. No.
Okay.
And I would still sometimes get the lawyers together to talk. Now I find that the lawyers don't even want to do that.
Wow.
They don't want to be in the room with the other side almost universally.
Okay.
And I've just stopped asking.
Oh, really?
It just doesn't go anywhere.
Yeah.
So, no, I haven't had a joint session in I don't know how long. A few weeks ago, I thought it would be helpful to have the lawyers talk to each other about an issue in a mediation, and they didn't want to do it. One side was like, yeah, okay, maybe. And the other side was like, no, I'd really rather not.
Okay.
So we didn't do it.
Yeah, no, that's an interesting take. When you get everybody together, it tends to raise the temperature between the sides. And, you're trying to, not do that in a mediation. So,
although in this meeting we had my colleague Lee J. Berman, who's a very well-known mediator, was talking about joint sessions he does in different contexts to incredible result. More like community mediation and the ability to use joint session to bring people together. He does an incredibly skillful job of that. But I don't find those opportunities in our cases, and I don't find those opportunities in the cases that I do.
Yeah. Okay.
Yeah, I think so. Part of the adaptation that we were talking about before, what lawyers have. So, one of the things that's changed in mediation is much greater use of mediators' proposals to close the gap.
Okay.
And so mediator, should I explain?
Yeah,
them?
and I was going to get to the tools. That's a good lead-in. To
Okay.
some of the things that come up. So,
Great.
yeah.
So a mediator's proposal is a tool that we mostly use at the end of the day, though you can use them in the middle of the day as well, and I sometimes do, more and more actually. But a mediator's proposal is usually at the end of the day. It's a proposal that the mediator makes to resolve the case, final number, for example. And typically it's not the plaintiff's number, it's not the defendant's number, it's some number that the mediator picks because the mediator believes that that's the number that gives him or her the best chance of settling the case. Used to hear mediators say things like, well, I think that's a fair number. But I think mediators more and more, it's less about what's fair and it's more about what's going to close the deal. Certainly is for me. My mediator's proposals are entirely pragmatic. It's really just the number I think will give me the best chance of getting 2 yeses.
Okay.
So what happens is that the mediator puts the number on the table, and it's a blind procedure where I put the number on the table, I give it to you, I give it to plaintiff. You tell me confidentially yes or no. Plaintiff tells me confidentially yes or no. Obviously, if both sides agree, we have a deal. But your answer is confidential in the sense that if you say yes and they say no, I will not ever tell them that you said yes.
And that's great because then it preserves the party. It's not setting a floor to restart negotiations at that point, too.
Exactly.
Yeah.
It allows you to say yes to something that you wouldn't say yes to publicly.
Yeah.
So, and that's part of why mediators' proposals work. Mediators have used mediators' proposals increasingly over the last several years. And so one of the things that's happened in mediation over the last 10 years or so is that the parties aren't negotiating for a final number. People used to come into mediation and they would be negotiating toward their final number. Now, more and more, people are not doing that. They're negotiating toward their final position, which they hope to establish in order to get the mediator's proposal that they want. So they're negotiating for the mediator's proposal. I think partly because of that, other reasons as well. Let me hit what the other reasons are, and then I'll get to the conclusion. Okay. Mediation has become much more routine. It's much more widely used than it was even 10, 15, certainly 20 years ago. It matters, but folks seem over the last few years to be more willing to walk away without a deal and say, we'll handle it down the road. We'll handle it at a settlement conference with the judge, or we'll handle it in a second session a few months down the road once we've taken plaintiff's deposition, or plaintiffs made their motion for class certification, or defendants made its motion for summary judgment. Either the motion's pending or the motion's been ruled on.
Yeah, that's interesting.
A lot of stuff does get resolved that way.
Yeah, but I think that's part of it. I think what you're picking up as a mediator is the parties, it makes business sense. It can make business sense to settle the case early. And as an advocate for my clients, it's like, well, let's take a look at it and see. But you really never know where opposing counsel is unless you sit down and have the mediation. They're not going to start, or if you ask them for a demand, it's going to be some pie in the sky number. Usually. Yeah. And it's not going to be their realistic number where you think it can go. So it's going to be a non-starter versus like you invest a day, see where it can go, see where they're ultimately at, where you're at, and if that can be bridged or not. And, it could be valuable. If they're way too high, your client's way too low, you realize you got to litigate. Right. But it was worth taking a shot at seeing if you can get it resolved somewhat early in the case before going through the litigations. And that's one thing as I'm getting older, realize psychologically, I don't know, maybe you know the psychology behind it, but like, and clients are like, well, let's just cut to our bottom line and call it the day at 11 o'clock in the morning and we'll walk. But there's a dance that has to be had. Yeah. The parties, and I don't know, my perspective is they seem like they have to have that back and forth and be invested in the process and have that play out. And I
Very
think you have to
often,
be
yeah.
patient with that.
Yeah. You can do them differently. You can do, and I've done, 3-move mediations. I've done 1-move mediations where I've asked defense counsel and plaintiff's counsel look, tell me confidentially where this really can settle. Don't give me a BS number, give me a real number. And I've had situations where people match, where the numbers match. And we've resolved the case without a formal demand or a formal offer.
Wow.
We've just had confidential conversations. Or I've had defense counsel. I know other mediators have too. You get defense counsel who's willing to make the first offer and make it a real significant, substantial offer where it's the majority of what they are willing to pay for the case, maybe not 100%, but it's a big chunk of what they're willing to pay to settle the case. It's enough to get the plaintiff's attention and counsel's attention. Say, okay, they're serious, they're in the ballpark, let's get in the ballpark, and you get it done, after a demand and an offer, and you get it done from there. You can do that, but a lot of times, yes, a lot of times folks, and you can see them working. I won't talk about any particular mediation, but you can see folks' minds working about how they're going to play the mediation out. And you certainly get folks who make the decision, hey, that's what I'm willing to put on the table for today. We'll let the other side go do some work, go spend some time and money on the litigation process, let it soak in with them that they're not getting out of this for what they want on the plaintiff or defense side. And then we can come back when they adjust to the reality of what things are. I see people go through that mental process all the time.
Yeah. What are some of the most common challenges you face as a mediator in mediation?
Sometimes folks have very often people have unrealistic expectations about what's going to happen, about where the other side's going to be, about how much they're going to be willing to pay or how little they're going to be willing to take, or I, as the mediator, I will at appropriate times, after we've talked about things, after I feel like I have a real grounding in a case and I feel confident about what I'm saying, I'll let folks know what I see, and it may be drastically different from how they've evaluated the case. And I don't play devil's advocate. I don't change my opinion based on what room I'm in. I just try to be very straightforward with people about what I see. So you'll see folks making an argument that, in my view, look, you might get a judge to agree with you. I think the vast majority of judges are not going to agree with you. I think the vast majority of juries are not going to walk down this road with you. But folks can take everything I have to say with a grain of salt, because I'm not their jury, I'm not their judge, I'm not their court of appeal. I'm just a lawyer with a bunch of experience who's neutral and very straightforward. And I think that's what I think when you have mediators who are evaluative, and some are more evaluative than others, obviously. I'm not Enrique Romero. Nobody is. Rest in peace, Judge Romero. But I'm happy to, when it's appropriate, to share what I see in a case. And I think folks do well to take that into account, because it's not for nothing.
Yeah. No, and it's good to have that third party perspective too.
Yeah, I mean sorry, I interrupted you.
No, it's good. It's good.
It's good to have that. It's good to have that third party, and that's part of what you're paying for.
Yeah.
Especially if you hire somebody who's got subject matter expertise, that's part of what you're paying for.
Right. That's why it's so key to have, I like having the mediator that knows employment, knows PAGA, class actions, if you're dealing with that, or the single plaintiff, retaliation, harassment cases, that has experience, knows how that's going to play out with a jury too.
Yeah.
Really quick too, I wanted to circle back to some of the tools you use during a mediation.
Sure.
So mediator's proposal, bracketing.
Yeah.
Any do you want to explain what bracketing is?
Sure.
So some of the people who might be listening, what to expect on
Sure.
that, how that plays out.
Sure. So typical situation, I'll start here. Typical situation where we use bracketing is plaintiff makes a demand of $1 million, defendant makes an offer of $1, plaintiff moves to 900,000, defendant moves to 10,000. It wouldn't really work that way. Plaintiff demands $1 million, defense offers 10,000. Plaintiff demands 900,000, defense offers 15,000. So the move slowed down. Plaintiff now makes a smaller move in reaction, goes to 850, let's say, or 875. Defense now slows down even more, 17.5. Plaintiff says, I can't respond to 17.5. They need to make a serious move. You go back to defense, they say, no, that's our move. 17.5, go get a move. Plaintiff doesn't want to do anything. Maybe they'll go to, they'll make a $5,000 move. They just want to match what defense has done. So very often in that situation, we'll use a tool called bracketing. And sometimes folks will say, no, that's too early for brackets or whatever. Bracketing is the way I like to explain it to non-lawyers is, so plaintiff will propose a bracket or a range. Plaintiff will say, well, we're willing to negotiate in a range between, let's say, 300,000 and 800,000. Okay, so I'll demand 800,000 if you offer 300,000 in response, and then we'll negotiate in that range. Usually what the defense responds with is, well, your range is too high, but we're willing to negotiate in this range down here. We're willing to negotiate in a range between 50 and 100, let's say, down there. And, plaintiff's range is like that. And then sometimes what happens is plaintiff will say, okay, well, 50 to 100 we're not doing that, but we'll negotiate between 200 and 500, for example. And maybe defense then says, okay, well, we're willing to negotiate between 100 and 200. So sometimes you get these brackets that touch at the 200 spot, right? Plaintiff said 200 to 500, defense said 100 to 200. Sometimes that's an indication of what's possible. Sometimes people are further apart than that. Sometimes you'll do a couple rounds of brackets back and forth. One party or the other will go back to hard numbers. That's fine. I'm going to come back to something that I sometimes do, but do you have a question or comment?
So instinctively then, everybody's looking at the midpoint of those
Everybody's
brackets,
looking
right?
at the midpoints, right? Everybody looks at the midpoints. Some mediators have a rule, do not propose a bracket unless you are willing to go to the midpoint, or an alternate version of the rule is when you propose a bracket, you are demanding or offering the midpoint. So in essence, when plaintiff says 2 to 5, they're making a demand of 350. That's the midpoint of that bracket. Or when defendant...
And I've had mediators say, don't look at the midpoint.
Right. Everybody always looks at the midpoints.
Right.
And usually if one side or the other, when they go back to hard numbers, if they go to a number that's not the midpoint or better, the other side's going to get very upset. Yeah. And so if I get a plaintiff who has proposed 200 to 500 and now they want to make a demand of 750, happens sometimes. We talk about the context where it's okay. But if there's been a couple of rounds of back and forth with brackets and they now make a demand that's higher than the bracket, that's usually going to go over very poorly. Defense is going to make an offer that's way lower than their midpoint. One of the things you can do as a mediator, so usually you'll go through a couple rounds of bracketing and somebody will cut back to hard numbers, and you're usually further down the road than you were. So brackets do a couple of positive things. One is they convey information, which is very valuable for me as the mediator and for you as parties. What are the parties willing to do? Because, right, when you get a demand of $1 million and an offer of $10,000, there's some information there, but it's not a lot.
Right.
When you get a bracket of 3 to 8 or 2 to 5 or 1 to 2 on the defense side, you start to really get a sense of where people are and what's possible at the end of the day.
Yeah.
And in that situation, you got 2 to 5 on one side and 1 to 2 on the other side. There's a settlement that's feasible. When, on the other hand, you get a bracket from the plaintiff that's like 6 million to 8 million, and the defense is like, we'll pay 100 to 200, you've got problems.
Right.
Right. You've
Right.
either got, you've got a lot more work to do,
Yeah.
is what you have.
Yeah. The bracketing's been coming up quite a bit.
Yeah.
That's a tool just to get the discussions going instead of
Right.
hard numbers to help parties keep moving?
Because it does two things, right? One is it conveys information, which is valuable. The other thing that it does is usually when folks get back to hard numbers, the hard numbers are a lot further down the road.
Yeah.
I used to get more lawyers who would tell me that they don't like brackets, that it's a waste of time. Last 5 years, lawyers are much more, I think lawyers are more knowledgeable about brackets. They're more comfortable using brackets, and they're more willing to use brackets, and they're more willing to do it earlier in the day. So that's another part of how mediation has how lawyers have kind of adapted to mediation, and how mediation has changed is increasing use of brackets.
Okay. Yeah. Any other tools come up?
Sure. One of the things that I'll do is when we're in brackets, I can propose, it's like a mediator's proposal, but it's not an end of the day number. I can propose that the parties negotiate between a set of numbers. Sometimes I'll do that after we've started working with brackets. Sometimes I'll do it before we get to brackets. Let's say a plaintiff makes a demand of X and defense makes an offer of Y, and we go a couple rounds and nothing's really happening, but neither side wants to use brackets. They just want to make small moves. I can propose a bracket. If I've got a real good sense that a case is going to settle in 6 figures, if it's going to settle at all, I may propose that the parties negotiate in 6 figures. I may, which means plaintiff demand under $1 million and defense offer of $100,000 or more. I may propose a different bracket if I have a sense that, if it's going to settle, it's going to be in this range. I can propose that. And it works the same way in the sense that I propose the bracket to you and to them. You give me a confidential yes or no. Again, if both sides agree, then we go forward from there. But if you agree and they don't, I won't tell them that you agreed.
Okay.
So that's a tool that I use sometimes. There are plenty of other things. Sometimes I'll suggest that people make true conditional offers, which is different from a bracket. So if I were talking with you and I were suggesting that you do a true conditional offer, it would be something like, look, we'll offer $100,000, for example, but the demand in response has to be 5 or below, or, say yes or no to this, but don't counter it with anything, because if your answer is no, we're going to just make an offer of 30.
Okay.
So that's a true conditional offer. It's not a bracket.
Okay.
So folks do that sometimes. I don't know. There are all kinds of tools that we can use.
Cool. There's a lot of different things. Conditional offers too. I've had it where maybe the defense feels strong about a pending MSJ, and you can actually negotiate terms. If you win on that, here's what we'll do. If you lose, here's what's going to be the result on that as well.
Right.
But fascinating. Yeah. So it's really up to the parties and the mediator's creativity to come up with those types of solutions. So,
That's right.
Yeah.
You can agree, for example, if a case is going to trial or arbitration, you can agree to a high-low that you won't tell the arbitrator what your high-low is, but it's a guarantee that the award will not be less than $200,000, for example, or more than $500,000, for example. So if the arbitrator awards 50, there's a private side agreement that will bump up to 2, and if the arbitrator awards $3 million, there's a private side agreement that will bump down to $500,000. So, for example, you can do things like that.
Yeah, that's great.
Yeah,
that's great.
I don't get that a whole lot. But
I haven't used that a whole lot, but it's just good to know that it's available.
And I mean, you're absolutely right. It's only limited by the parties and the mediator's creativity.
Yep. Now, I wanted to turn to your research about PAGA.
Sure.
We say PAGA, that's a Private Attorneys General's Act, and it's this unique law to California. And to some of the listeners that might not know, but I think most of our listeners probably know about it, but really quick, it's this law that incentivizes enforcement of civil penalties that were only able to be collected by the state of California for labor code violations. And the legislature, the labor commissioner basically ran out of resources to enforce these civil penalties. They weren't being enforced. So the legislature said, we'll privatize plaintiffs' attorneys to go enforce these civil penalties under the Private Attorney General's Act, PAGA. And the attorneys get to keep, the plaintiff's attorneys gets to keep their attorneys' fees. 75% of the recovery of these civil penalties go back to the state, and then 25% goes to the plaintiffs involved. And it's kind of like a class action, but kind of not. It's unique under California law.
Right.
And we're just getting into some clarification nearly 20 years after it's passed,
Yeah.
more than 20 years after.
Yeah,
about
20 years.
20 years, yeah.
Mm-hmm.
20 years to
Yeah.
this year, actually,
Right.
yeah. On some clarifications on this. And, in my experience too, when I got out of law school, 2002, PAGA was just kind of a tag along claim in these class actions. It wasn't given a whole lot of value by plaintiff's attorneys at all in those cases. But then really with the enforcement of these class action waivers and arbitration agreements,
right,
employers started implementing the arbitration agreements. Class actions started to go away. We had this support from the federal level under the FAA to enforce these class action waivers.
Right.
So plaintiffs' attorneys here in California have been turning to PAGA a lot more recently. You've noticed that too, I suspect.
Oh, yeah.
And
there's
that's
statistics on it.
Yeah. Where all of these wage and hour representative actions are being brought under PAGA here recently in California, the last few years.
Right.
You've done this study going back 20 years. I think it's probably the most in-depth study of PAGA to date, looking at trials on PAGA, right? And verdicts. Could you tell me a little bit about the study?
Yeah, absolutely. So just a little bit more on the background. So the U.S. Supreme Court rules in a case called AT&T Mobility versus Concepcion. It's a consumer class action case where there was a class action waiver in the arbitration agreement. The Supreme Court rules that that's enforceable, the class action waiver. That's 2011, I think. PAGA's been around since 2004, but it was very lightly used. After Concepcion, more employers start requiring employees to agree to mandatory arbitration. And so in 2014 is the year when you see the number of notices filed with the LWDA jump from 400 or so to 4,000 or so. And that's where it's been since then. So I've been interested for a long time in what happens when PAGA cases go to trial. And so I've collected PAGA judgments for a while after trial judgments. And my colleagues, Julie Trotter, who does defense work at Collin Jensen, and Jennifer Kramer, who does plaintiff's work at Hennig, Kramer, Ruiz, and Singh, and I have been, over the last year in particular, we've made a full court press to collect as many of these judgments as we can, and to analyze them. And so we're writing an article that'll come out in July with our results. And we gave a presentation last month at the LA County Bar Association on our results, kind of a sneak peek.
Great. Yeah, we've got those slides. Those are available, right, for people from your LA County Bar Association presentations. So got those. Going to talk about those here in a minute. But I want to step back to what are your thoughts? I mean, there's a lot of PAGA cases filed. Are they being tried a lot?
So we've collected, I think it's 75 judgments. I think that we've got more from 2017 than any other year. I think we have 8 from 2017, something like that. I don't have any doubt there are plenty of judgments that we don't have in our possession. I'm hoping that after we publish our article and as we do more events, that we'll collect more and more. I've gotten another 3 or 4 since we did the LA County Bar thing. So, yeah. What was your question?
How much are they? Yeah, so they're
how
just
much
not
they go
tried.
to trial? They don't go to trial very often.
I think we're seeing about 7,000 PAGA notices filed a
Right.
year right now.
Right.
It's increasing every year.
Right.
And you've put out this call statewide to collect, judgments that have
Right.
actually been tried, for cases that have been tried. And we're looking at 70. If I were to guess, I bet you've probably got the vast majority. Worst case scenario, you've probably got 50% of the cases out there. I would guess.
That would be my guess too. Maybe it's 100 to 150 that have been tried.
Yeah. So it's just not a whole lot
Not a
compared
whole lot.
to 7,000 filed a year. Or
Yeah,
7
it's high
notices.
stakes litigation.
Yeah.
You know, they're for both sides.
Yep.
So I mean, it's not surprising that not that many go to trial. Plus, I think there's a lot of uncertainty about how to actually try these cases, because you're right, it's like a class action, but it's not. It's a representative action. And so I think there's some uncertainty on both sides of the bar and on the bench, meaning judges, about how to try them.
Yeah. 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 And it's not a jury trial. So
Correct.
It's a trial in front of the judge.
Yeah, some of the ones that we found have gone to jury trial, but the Court of Appeal has held that it's not a jury trial.
Yeah.
Sometimes you'll get an individual case with a PAGA component. Sometimes you'll get a class case with a PAGA component. So there may be issues that get tried to a jury. Whether the employer provided meal periods, for example. If there's a class claim and the parties want that to go to the jury, that'll go to the jury.
Okay.
So anyway.
Yeah. So your numbers, what stood out based so far? And I know this article's still coming out, but what's really stood out for you with the research you've done?
So we found that plaintiffs won more than half of the cases that we have. Judges awarded penalties under PAGA in something like 55 or 56% of all the cases that went to trial. That's excluding cases that were retried, because sometimes you'll get a case that goes to trial, plaintiff wins, goes up on appeal, get a partial reversal, and it goes back for a retrial. So that's not including the retried cases. It's also not including default judgments. We have a few of those. Okay. But yeah, we found that plaintiffs won a little bit more than half. Courts awarded penalties in a little bit more than half. There are a few cases where courts found violations but awarded 0 penalties.
Okay. The court's got discretion
reasons.
To reduce penalties or not award the penalties at all.
There's a lot of appellate authority that says that the penalties are mandatory, but courts have discretion to reduce them. The statute itself says that courts have authority to reduce. Whether they have authority to reduce to 0 or not is not entirely clear in my mind. There's one case where the court awarded 0, found a violation, awarded 0, it went up on appeal. It was affirmed on appeal, but it's an unpublished decision. So a little bit unclear whether they can reduce to 0 or not.
Okay. Was that surprising to you then, the finding about 50% recovery, or was that what you kind of expected?
I really thought it would be very close to 50%. My guess is that as we add more and more judgments, it'll probably come down closer to 50. Right now, it's closer to 60.
Okay.
But Phyllis Chang, when she was director of the Department of Fair Employment and Housing, commissioned a study by RAND and UCLA of FEHA cases, harassment, discrimination, retaliation cases. Far more of those go to trial than PAGA cases. And their finding was that it was almost exactly half. The cases resulted in plaintiffs' verdicts and half resulted in defense verdicts. It's random.
Okay.
And so my guess is that as our data set increases, we'll regress.
Okay.
I don't know.
Yeah.
I'm not even know if I'm using the word right, but we'll get closer to 50% is my guess.
Okay. Is the research showing any, it was a couple better cases than others that are going to trial and winning. Any findings on that so far?
Yeah. Jen Kramer, my colleague on the project, she handled that aspect of it. When we did the presentation for LACBA, she talked about standalone Labor Code Section 226 cases. So cases where Labor Code Section 226 requires employers to provide timely and accurate wage and
Pay stubs.
pay stubs, thank you, wage statements, I call them,
Yeah.
to their employees. And so you can have standalone 226 cases where the allegation is that the employer has done something wrong, not listing their name or address or not providing the dates of the pay period or whatever it might be. And so she found a higher than average success rate for plaintiffs in those cases, lower than average success rate for plaintiffs in suitable seating cases, cases alleging that employers under the wage order should be providing seats to, for example, retail cashiers. And plaintiffs, to our knowledge of the cases that we have, plaintiffs have not won any of those. I think we have 5 suitable seating cases that have gone to trial and defendants have won all of those.
Okay. The number that stood out for me, though, in the slides that you previewed at the LA County Bar was the mean award, 2.47.
Yeah.
That's a big number.
Yeah.
And like you said, it's high risk litigation. So when it is awarded, we're talking major money here.
Can be, yeah. The mean award, the mean request was almost 13 million. The mean award 2.4. We've added a few cases since then, and the numbers come down a little bit, but still over 2 million. The median, though, median request just over $1 million. Median award just under $100,000. The difference between the mean and the median, for folks who don't know at home, mean is what we normally consider the average, right? You add up the values and divide it by the number of entries. Like whatever we always think of as average, that's mean. Median is you've got a data set of, let's say, 11 values, and you rank them from highest to lowest. Median is the number where half the entries are above and half the entries are below. So the median is lower because if you look at the requests, for example, I think 18 out of the 37 requests that we had in the chart were below $1 million. So the median request, even though the mean request is almost 13, the median request is $1 million because you got so many more cases that are smaller, and you've got a couple cases at the top. There was one case, I think, there's one case where the demand was something like 166, and another case where the demand was something like $122 million. And so those, drag the mean way up. Yeah. The median case was something like 2,700 pay periods. So half the cases that we looked at had 2,700 or less pay periods. Half the cases had more than that.
Okay. And 2,700 pay periods is relatively small.
That's a small case. Yeah, that's a small case. That's a case that should not go to trial.
Right.
Under any circumstance.
Right. Yeah.
Really.
Yeah.
But somebody has made a bad decision in having that case go to trial. Maybe both sides.
Yeah. And that's why, and it's hard. And, I understand from my clients' perspectives, running a business in California, it's difficult with the regulations.
California wage and hour law is very, very tricky. It takes a lot of time and effort, and you've got to have good counsel advising you. Got to have somebody like you on your team telling you what to do and what not to do.
And it gets emotional.
It's very complicated.
When you're getting dinged with all these lawsuits, and a lot of them feel like they're frivolous, and you're doing everything, you're trying to do everything right, and you still get dinged with them.
Right.
100%. And I could see the client's perspective, like, well, if I keep settling, is it going to buy more litigation?
Right.
And,
right.
I'd be interested to hear your thoughts on that, if you see that play out. But you've got to look at these cases like a business decision, and that's where your lawyer should be helping take the emotion out of it.
Right.
I think it's good having when you go to a mediation, you've got another third party assessing the case, helping you assess the case, and kind of telling you where just realistically this might end up.
Right. I think folks don't realize how expensive litigation is, not just in terms of the cost of your lawyer, but the time that your top people are going to have to invest in getting answers, pulling documents, pulling policies, going through personnel files, et cetera, sitting in deposition, sitting in mediation, preparing for trial, it's all very time intensive, and it's the kind of thing that'll keep folks up at night and keep them from focusing on their business.
Yep.
So there are a lot of costs to litigation beyond just the dollars. I think folks don't realize it.
Yep. Yep.
A lot of good reasons to settle cases beyond the dollars. Of course, there are the concerns about, if I settle this, I'm just putting a target on my back. Totally get that, and that's part of that should be part of a business's calculus in deciding whether to settle a case or not, or where exactly to settle it.
Right. On one other question on your study here, cases on appeal.
Mhm.
Anything stand out with you on that?
Yeah.
So it's been tried. The PAGA case has been tried. It goes up on appeal. Are they being affirmed on appeal? Tweaked on appeal, coming back?
So what was interesting there to me, we found that I think it was 17 or 18% of the cases that went up on appeal got reversed. That's the same as general civil litigation. 35 or 36% of the cases were affirmed in part, meaning, for example, the court said, yes, the trial court got the law right on this part of it, but got the law wrong on that part of it. Like, yes, there was a violation. The employer did violate Labor Code Section 226, but you, trial court, awarded penalties at the subsequent rate, and you can't do that. And so we're going to affirm in part, reverse in part, remand with instructions to do X, Y, or Z, recalculate the penalties, for example. And that 35 or 36% is much higher than general civil cases. And I think that's because PAGA is such a new statute. It's 20 years old. It became effective in 2004, and new statute, not that many cases going up after trial, and so there are a lot of instances of courts saying, "Yeah, you got this right, but you got that wrong. Try again."
Yeah. And like you said, the bench is still a lot of these issues. It's 20 years old, but in terms of laws, it's a relatively new law. And it hasn't really been focused on until, like you mentioned, when
last 10 years.
Yeah. And so it's really, it's evolving here. We're getting a lot of guidance from the courts. So as that moves on, we'll get that should play out a little better. But it's interesting to see how much it's reversed on appeal.
Yeah.
Really interesting. So July, we're going to expect that article. That'd be great.
Right.
Looking forward to that.
Yeah, it's running California Lawyers Association Labor and Employment Law section review is their magazine, and it'll be in that.
That'd be great
in July. Yeah.
Cool.
Yeah.
So one last question. We'll wrap it up here. I've taken a lot of your time. This has been interesting.
No, it's been great.
I could go forever, actually. So future of mediation, where do you see it going? In technology, do you see anything happening with technology? Different practices, processes on mediation? Any thoughts on that?
Yeah. So mediation is at this point firmly entrenched in litigation practice. I don't see that changing anytime soon. Lawyers are, I'd say, relying on mediators more and more to communicate with opposing counsel, and that trend doesn't seem to be reversing. I don't see it reversing anytime soon.
Okay.
The technology question is really fascinating. There's a lot of conversation among mediators about the use of AI in mediation. I think it's very problematic, but interesting. And
why do you think it's problematic?
Well, confidentiality concerns, among others.
What if you could have your own system?
Right, closed system. Yep. I don't know. I don't know how you would use it. I know folks are using it for ideas for writing and maybe writing articles or coming up with presentations entirely. I call me a Luddite if you want. I like to do things myself. I was just listening to a podcast about it, Ezra Klein's podcast, And he was saying how the real hard work in writing, people are using AI to come up with rough drafts, first drafts of things, but the real hard work of writing is in the first draft, because that's where you're really sorting out what you're going to talk about and what you're not, what works in an article and what doesn't. And what happens to your writing when you skip that step? What do you lose later on? And I don't know the answer to any of that. I just know that for me, I love the writing process. I love writing. And in terms of media, I don't even know what you would use AI for in mediation.
Could you ever see it stepping into the role as a mediator?
I can't at all, because it's such a human interaction. I know the capabilities of these systems is growing exponentially, and they're going to be capable of doing things that most of us don't realize in a very short amount of time. They're going to be able to do things that we can't even imagine that they would do. But it's hard for me to imagine how a computer system, large language model, generative AI, any of that is going to be able to help parties resolve disputes without human interaction. I don't get it.
I agree.
Yeah.
And when AI came out and ChatGPT, I was playing around with it. I was amazed what it could do. But the more I play with it, I'm finding its limits too. And I understand it's evolving quickly, but I agree. And going back to what we spoke about earlier, the process of a mediation and sitting down, and I call it the dance, but going back and forth, investing the time and having people involved in that, there's something psychologically, I think, in that process that has to happen for people to get to a resolution point, versus everybody submit mediation briefs to ChatGPT, and it could go out and do all this PAGA research, come out with a perfect where the case should settle. But I think the parties are still going to say, well, I don't agree with that. But it'd be interesting.
It'll be interesting to see. I was just listening to the guy who is the CEO of, there's this company, it's called Anthropics, I think, and they've got an AI called Claude. And Claude apparently is the most human-like of the interfaces of the AI systems at this point. And he was talking about some of the things that they'll be able to do, like you tell Claude that, or whatever system, that you're going on vacation, and it'll plan the whole thing for you, book your hotel, book the restaurants, the type of restaurants that you're going to like, et cetera, plan your trip for you in a way that you want. And he said that type of tool will be available in the next 3 to 24 months. Just unbelievable, leaps and bounds. So is there the possibility that these systems will be able to help in some way in mediation? I suppose. I have no idea how. I don't have the imagination to think of how they're going to do it.
It'll be interesting to watch. So before we go, any resources? We were talking about some books, I'm sure we have some lawyers listening, but for the lawyers that want to learn more about the negotiation process, but how about parties too? And, I've got a lot of defense clients. My clients are companies, if they're going through mediation or negotiation, any recommendations or resources that, and it doesn't have to pertain to mediation, but even negotiation, anything you've found really helpful that you've studied or read?
The best book that I know of is the one I mentioned before, Thinking Fast and Slow. It's kind of tangentially related. It's really more about human decision making. That's the one that comes to mind.
Okay. Yeah. That'd be great. I'll check it out.
Yeah.
We'll put a link to that.
Oh yeah. It's a terrific book.
That'd be great.
Yeah.
Great.
Yeah.
Steve, where can people reach you?
Through your friendly neighborhood lawyer. StevePearlMediation.com.
Okay. And you're writing articles routinely as well. You've got a blog as well?
I don't.
Oh, okay.
No, I used to.
Okay.
For probably 10 years, wrote about employment law developments. But yeah, I stopped that.
Just too many to keep up with.
2016 or something. Yeah, it was.
But you're doing podcasts. Yep. And,
yeah, I write and speak fairly routinely. This year, I'm doing a number of these presentations on the PAGA research.
Okay.
And then at the end of the year, I do a program to help lawyers learn to do a better job in mediation. We did that in December up in San Francisco, had a great panel of mediators, plaintiffs' lawyers, defense lawyers, and we'll be doing that again at the end of 2024. We
Okay.
do that through the California Lawyers Association, Labor and
Was that
Employment
the
Law section.
mediation?
Advanced Mediation
Yeah,
Conference is
I
what we call
attended
it.
that years ago. That was
Yeah.
great. Yeah.
Yeah. Oh, thanks.
Yeah, that was great.
Thanks.
So, yeah, if we have a link, we'll put that into the show notes
Sure.
here too and share that. But I really appreciate your time coming in, explaining the mediation process. I could
Thanks for
sit here and
having me.
talk about it for hours.
Yeah. It's fun.
But yeah, maybe once your article's finalized, we can have you back later this year and
Sure.
talk about PAGA a
Yeah.
little more in detail.
Be happy to.
That'd be
Yeah.
great.
Thanks so much for having me. This was fun.
Yeah, thanks for coming in.
Yeah.
Thanks, Steve.
My pleasure.
Okay.